Welcome to the 2022 Current Issues Workers' Compensation Conference, brought to you by the law offices of Richard L. Montalbo and sponsored by Apple. Innovation for your world. LexisNexis, not just more content, but more efficient research tools. Gemini copying and subpoenaing services, assisting both the defense and applicant bar. Arcadia and John Pinto, your structured financial settlement professional. MacroPro copying and subpoenaing services. MedLegal legal services. ExamWorks, provider of workers' compensation evaluations. MedLink, professional medical legal evaluators. And Amitros savings and support for injured workers. This year's conference was again virtual, but webcasted from the historic and elegant Vizcaya in downtown Sacramento on March 11, 2022. Before we begin, you may wish to download the conference materials, which are available without charge at montalbolaw.com. Should you be interested in CEB, MCLE or QME credit, please contact the law offices of Richard L. Montalbo for terms and to receive your certification of completion. The opinions expressed herein are the opinions, legal interpretation and analysis of the presenters. The viewer of this video presentation is encouraged to review in its entirety the case decision or statute which is being discussed. The 2022 Current Issues Workers' Compensation Conference involved 4 separate panels and sessions of just over 1 hour and 30 minutes each, and qualifies for 5 hours of CEB, MCLE or QME educational credits. The first session will be Case Law Update, Part 1, with the focus on case decision originating with the WCAB. The areas of emphasis for this year's conference will include apportionment, permanent disability, litigation involving COVID, and jurisdiction. The panelists include Mr. Jacob Marcus, retired Judge Dudley Phoenix, and Richard Jacobs Myers. The moderator for this session will be Mr. Richard Montalbo. Let's begin by introducing each of this year's panelists. The first member is Mr. Jason Marcus. Mr. Marcus attended California State University, Sacramento, and upon graduating, attended University of the Pacific, McGeorge School of Law, graduating in 2008. Mr. Marcus is a partner in the firm of Marcus, Regalado & Marcus, located in Sacramento, California. He is a member and past president, secretary of the executive board, as well as being on the board of directors since September 2010 of the California Applicants Attorneys Association. Mr. Marcus is also a workers' compensation certified specialist and exclusively represents injured workers. Joining Mr. Marcus is retired Judge Mr. Dudley Phoenix. Mr. Phoenix is a graduate of UC Davis Law School and was a workers' compensation judge with the Sacramento WCAB for over 2 decades. He is currently in private practice which focuses on representing police officers and firefighters in Sacramento. Mr. Phoenix was recognized in 2006 as one of Sacramento's best lawyers by Sacramento Magazine and continues to be a leading voice in the state of California in the field of workers' compensation law. Next, Mr. Jacobs Myers is perhaps the leading authority in the field of California workers' compensation law. Mr. Jacobs Myers attended St. Mary's College 1968 to 1972 and earned his law degree from University of Santa Clara School of Law, JD 1975, where he graduated cum laude. He is currently employed with Shaw, Jacobs Meyer, Crane, Claffey and Nix, representing defendants in workers' compensation litigation. Rounding out this panel as moderator is Mr. Richard Montalbo. Mr. Montalbo holds degrees in business economics and computer science and received his law degree from the University of the Pacific, McGeorge School of Law, where he is currently an adjunct professor. He is also the architect behind Current Issues Workers' Compensation Conferences and a frequent presenter at various legal conferences and symposiums throughout the state of California. Mr. Montalbo is also the app developer and designer of the CompCalc, the industry's only smart device workers' compensation rating and indemnity app. He is also the author and editor of the Work Comp Index, a topical guide to the law of California workers' compensation. Let's join our panel already in session.
Okay, let's go ahead and get started. Let me start by welcoming everyone to the 27th annual Current Issues Workers' Compensation Conference. Once again this year, I invited what, in my mind, are some of the top legal minds in the field of California workers' compensation to participate. My name is Richard Montalvo. I'll be the moderator. I'll also be presenting some of the materials here today. Let me start, before I introduce the presenters, let me start by making sure that everybody has downloaded the materials. If you go to montalvolaw.com, you'll find the materials. There's a button there. You can download the materials. If you have a problem with that, it's probably because your firewall is set up and it's not going to allow you to download that. But there's a way around that. Call my office, and I've got ladies standing by to take those calls, and they'll help you out. Let me give you that phone number. It's 530-529-9860. So be sure and download those materials. Let me go through what the materials are this year. There's really two large components to the materials that we'll be going over today. The first aspect, the first 20 pages or so, will be part of the primary part of our presentation. But because you're anybody who attends and wants CEB, continuing educational units, because you're going to get 5 units and the actual presentation is going to be somewhere in the neighborhood of between 3.5 and 4 hours, there's a self-study segment. And that's why the first portion is the case law update, and the second portion are the entries for the Work Comp Index since last March. Half of these have been included in the 2022 Work Comp Index. Some of them will be included next year. So what I would challenge everybody that wants CEB units is take the time. It could be an hour, it could be 3.5 hours, but take that additional time to make up that additional period so that you get that full 5 units. And the way that this works is once you, if you want the full MCLE specialization QME certification credits, you need to contact my office. We'll send out a declaration. You have to sign it under penalty of perjury. There will be an audit. No, there won't be. But you have to sign that declaration. We're going to go ahead and keep those in case we're ever audited. And then you'll get a certificate almost suitable for framing for 5 MCLE or specialization units. Next, let me talk a little bit about the CompCalc. You know, we introduced the CompCalc in 2015. Originally, it was just and I know both of the presenters here live use the CompCalc. Do you?
Oh, yeah.
Do you, Dudley?
I do.
Oh, wow. I thought I was going to be walking on thin ice there. I wasn't sure. But the CompCalc was originally introduced in 2015. Just the basic. In 2016, we worked and were able to introduce the Plus, which is a full rating. The year since then, we went ahead and introduced the iOS, the Droid version, the Mac OS for Mac computers, and then ultimately the version for AWS. We added additional features and functions. I don't have anything special this year to add other than we've increased our partnership agreement. Of course, the California Applicants Attorneys have a license, and it's on their website for paid membership for the AWS, the internet version. But we also have signed a license for the iOS, which is the iPhone, iPad, and for the Droid devices at the App Store for the tablets and the Droid phones. With the following. Originally, we had a license agreement with Gemini Duplication. And if you want to download the updated version, go to either the App Store or the Google Play and put my name in and download free of charge today the Gemini version of the CompCalc. You can download that. But we're also going to have in the next few weeks 2 other partners, Matrix and also Republic. These are both photocopy and subpoenaing services. And so they'll be available at the App Store and the Google Play. You may ask yourself, well, why do I want, if are they all the same and which version do I want? They are all the same as far as feature and function. The distinction is on each one, depending on who you use as your photocopy and subpoenaing service, if you have your iPhone or your Droid device and you tap on the logo, for Matrix or Republic or Gemini, you're going to go to their website so you can place your order literally through your device. So that's the distinction between those. If you have any problems with downloading that, let me know. I will also tell you this, the iPad's coming out with a new OS. I don't know if everybody knows that. It's only been released to the developers thus far. and we have to update the iOS, which is also for the iPads. We have to update our version. So before if you want to use on your iPad the CompCalc, do not update for about 2 weeks, because then we'll have the updated version that'll be consistent, or you'll be able to use it with the new updated OS. Okay, let me go through the day's events, and then I'll introduce our speakers. The first session, both sessions are going to focus on case law update, cases that have come down there in the past year. They'll be assigned. I'll be trying to keep everything on time. I'm not sure that we can get through the amount of materials that we have here, but we're going to make a good effort at doing that. The first session starts at 8:45. It's going to continue to 11. We're going to take a break from 11 to 11:15. Then we'll resume with the second session from 11:15 to 1 o'clock. And then we'll take a 15-minute break. And at 1:15, probably the most important aspect of the conference will occur, and that's the raffle, the giveaway. And I've changed some things on the raffle as well. We're using a clear bowl with large names, and I won't be pulling any of the names out, so there can't be any shenanigans, and I'm kidding, there never has been, nor has there been any accusations to that extent. Okay, let me introduce our speakers, and I'm going to start with a gentleman that, with a little story. 3 years ago, I asked this speaker to participate. And he said, sure, I'd love to participate. And I said, great. He said, send me the date. I sent him the date, and about a month later, he says, oh, Rich, I can't go. I can't do it. I said, why? And he says, oh, my wife booked a trip down under to Australia. That speaker went down on that trip. And I said to him before he left, I said, Jake, please, Rich, I like you, but I love my wife. So Jake went down, and we know what happened. And I'm just going to say this from the heart. During that period of 4 to 6 months, that Jake, for those of you who don't know, he came down with COVID, a pretty serious case. I, for one, thought about him as I heard, and I think the whole industry felt this way. And I'm not a religious man, but I did find myself saying prayers. And I hope I'm not embarrassing Jake, but that's how I felt, honestly. But anyway, Jake Jacobs-Meyer is probably one of the top, if not the top. I say one of the top because I have an ego too, but he certainly is probably the top defense attorney in the state of California. He's with the firm of Shaw Jacobs-Meyer et al. And what I would say is when Jake lectures, when he speaks, I listen. So we're happy to have him on board. And last year it was 2-on-1. I don't know how many people watched it, but I had 2 applicant attorneys, and I was trying to hold back the hordes, and I don't know how well I did, but now we have Jake, so I feel like I have some reinforcements. Also joining us on our panel, and here's my story about the next gentleman. All judges, WCJs, are competent. They absolutely are competent. What distinguishes the really good judges, the great judges, from the other judges is judicial temperament. And retired Judge Phoenix certainly ran his courtroom, and perhaps I flatter myself, the way I would run mine. He was pleasant to deal with. He was strict, but he was always fair and certainly competent. And he was invited back because last year we had such great ratings, and I appreciate your participation. The last gentleman who bears the last name of a famous applicant attorney who is pretty much retired. Is your father doing any work?
I'm not supposed to use the R word. He's slowed down. Okay.
Jason Marcus. Jason's father, Mark Marcus, and I'm going to say this because he called in today, Mark Marcus has the distinction of being the only person, applicant's attorney, who's ever received a stipulated 100% award from me on a case. And that's because there were successive pending penalties. My client was paying $10,000 to $15,000 a month on medical care, and we negotiated a deal where we were able to resolve that. But Jason Marcus, the apple doesn't fall far from the tree. Jason first spoke at my conference 12 years ago?
Gosh.
15?
Yeah, maybe.
It was a while ago. And he was on a panel, and I introduced that panel as the Young Guns. He was a young gun back then.
Yeah.
And Jason, I'm not even sure what the topic was, but he spoke with another younger defense attorney and did a great job. Since then, he's become a partner at the firm of Marcus and Regalado. He also is a past president of CAW. He's actively participating in CAW, and certainly is one of the applicant attorneys in the greater Sacramento area that everybody looks up to. Okay, we're going to go ahead and begin with our presentation, but before we begin, I just want to tell you how I look at cases, and this may or may not be a benefit, I don't know, but listen to what I do. When I read these cases to put in my book, I look at two things. Number one, rather than when a case comes down, I want broad application and say that it applies to all this, I kind of look at it narrowly. What is the kernel of truth? What's the doctrine that I know I can rely on? And an example of that would be Halkitis. When Halkitis came down, I had a number of conversations, I know, with Jason at CAW, and I said, listen, it doesn't mean that you can sanitize through surgery your right to apportionment, but where you have a new condition, a new diagnosis, you're probably going to be prevented on the defense side from obtaining apportionment. So that's the first thing I want you to think about. Look at these cases narrowly. The second thing, the second doctrine that I want you to think about as we go through these cases is this. How do we understand, how do we come to understand the cases? How do we explain what the holding is? And where there's confusion, can that be explained through the following? And apply this and see how often it applies. Is the holding nothing more than application of the doctrine of substantial evidence and burden of proof? Because so often cases are resolved because one party didn't meet their burden of proof with substantial evidence. And you're going to see that in some of the cases that we go through here. My notes, I criticize some of the decisions. So we're going to start with Jason Marcus. He's going to tell us what's hot and what's not from the California Applicants Attorneys Winter Conference.
Thanks, Rich. Appreciate the intro. Nice to be here. So there's a few cases that, did they get in your materials or not? I don't remember.
They did not.
Okay, so.
And so what were you giving cites on these cases?
Yeah, so do you want to start going through the cases? Or you want me to give kind of a top level view first?
Why don't you give us a top level view and then we'll get to the cases.
Yeah, so kind of the things that are on the radar with CAW. You know, the new med legal fee schedule is obviously a big deal. You know, CAW participated in the meetings for years, literally years, between the DWC and the various players as they've sought for some time to update and revise the fee schedule. You know, we're kind of a side player, right? We want to make sure it works for everyone, but we're not the payors or the payees. But now that we've had this new fee schedule for, the better part of a year now, a lot of growing pains, figuring out, fights over the reporting that you need, what records go to the doctors, making sure the declarations get to the doctors. When do you need to send a declaration? Those have been a lot of things that they're very kind of just pragmatic issues we have to sort through, but it's been a lot of kind of extra work, I'm sure, for the defense attorneys and carriers that are watching.
Can I ask you a question? Just on the records that go to the doctor,
yeah.
How are you handling that? When a defense attorney wants to limit the records, and I'll just throw this out to everybody on the panel, when we want to limit the records, how are you able to, are you cooperating? Are you saying, no, everything goes? Or what are you doing there?
So my position is that everything should go. And if they are unwilling to agree in principle to that, I'll go down to the board and hash it out. And generally speaking, in Sacramento where I practice, the judges have been receptive to my arguments about more should go rather than less, because as we know, if a doctor doesn't review the complete medical record, their report is likely not substantial medical evidence. That being said, what I'm seeing more often now is that a defense attorney will go through subpoenaed records and remove things like cover pages and duplicative records and empty pages. And, so they'll take 1,000 pages of Kaiser records and take it down to 850 pages. And they've removed, the 6th page of every Kaiser note, which is nothing more than a header and a footer on the page. That I'm okay with. But if someone's going to go through records and say, this report is relevant and this report is relevant, but these studies and these reports are not relevant, I'm going to have a much harder time with that. One, it's hard for me to justify the time to do that with records, but two, I'm not a doctor. I don't think I should be deciding what report is or is not relevant before a doctor has seen it. I don't know how.
Well, let me ask Jake. Jake, how are you handling that with your clients when they want you to limit the records?
I'll tell you what I typically do is I will contact the applicant attorney and say, listen, we've got, like, I just had a case, we had 3,600 pages of records. Many of the records involved duplicate records that had gone to separate different Kaiser facilities. So a lot of them were basically the same records. Some of them were records that, at least from an orthopedic standpoint, were clearly irrelevant. Things that had to do with the applicant's cardiac status, which was normal, but they had all kinds of workups for it, none of which showed anything. And I usually go through the records, pull out everything that looks like it might even be remotely relevant, and submit that as a package to the applicant attorney and say, here's what I propose to send to the agreed medical examiner, QME. If you have additional records that you want to go to the doctor, let me know, because I'm not perfect. I don't necessarily see everything. But I was able to take those records down to about 800 pages, which obviously saves my client like $2,800 worth of medical record review. As Jason notes, a lot of those pages are empty pages, cover pages, the end page that says, end of note, that kind of stuff that doesn't really carry anything. But a lot of it was just simply duplicated stuff. You get a lot of duplicate stuff, particularly in Kaiser records. And I'm just not sure that it's necessary to send all the internal medicine. I also kept out the HIV stuff. That's stuff that should not go to an orthopedic surgeon, and he definitely should not be seeing it. One of the cases, I held out a whole bunch of records involving the applicant complaining to her doctor about her boyfriend having an affair with somebody and had he transmitted the sexually transmitted disease to her. I kept all that stuff out because it's not relevant. So those are the kind of things that I try and pull out of the records so that I'm not having the doctor review. And a lot of times, I end up saving my client hundreds, if not even thousands of dollars by doing that. On the other hand, if I only have 160 pages worth of records, period, I'm not going to spend a lot of time going through those. I'm not going to save any money for my client. The doctor's going to charge the same thing anyway.
Before I ask Judge Phoenix how he handles this, just one comment, and this is going to look bad on my part, but it's just a commonsensical question. How are your clients paying for this? Because one of the problems that I have is how to charge my client for what's going to be hours of record review. What we've done is one of two things. Either I write for authorization ahead of time, and I say, I don't know how much I'm going to save. We may break even. It may be, more cost effective just to send it. Or the other thing that we do is when we do our summary of records, we take it out at that point so that when I'm summarizing my records, I'm removing and getting ready for that medical legal. But there is an issue with paying for my efforts in that regard from my client.
The cost for me to review that, by the way, I've always disclosed it to my client, this is what my practice is, how I'm going to do it. But the cost for reviewing those records and pulling that out is probably less than 25% of the doctor's charge for reviewing those records. It's just not going to be anywhere near the amount that a doctor's going to charge. Even
for the fee schedule.
I think that 3,000 pages, when I end up going through it, pulling out the stuff, consolidating, identifying what I wanted, it spent about 4 hours.
Have you had to go to hearing on that issue yet? Because I hear Jason's argument all the time that, I'm not a doctor. How do I know what the doctor should review? It won't constitute substantial evidence unless it's a full, complete, accurate medical history, which requires a full review of medical.
Yeah, I haven't had the argument yet. Most applicant attorneys have been okay with it. And for many of them, it's still new. The argument I've heard that from is from doctors. They'll say, how do you know what records to send and what records not to send? And then that can be an issue. That's why I give the applicant attorney a chance to look through the records that I'm going to send and say, is there something else? I just had a case with a hearing loss. I had 1,800 pages of Kaiser records, some of which directly related to hearing loss. The applicant actually had multiple had evaluations, had consideration. There were tests. I extracted all that out, but we ended up with like 170 pages of hearing loss. And then I also included a whole bunch of contemporaneous, just general medical evaluations, because that's kind of the record that's going along with it. Anything that mentioned hearing got extracted and was included in the records. And the applicant attorney was fine with it, came back with a report, said, yeah, guy's got a hearing loss that's related to work. It worked out for both sides on that event.
Yeah, so cooperation. What do you say?
Well, I agree with what Jason said. My fallback is that everything should go to the doctor. But with that said, I've been working with defense attorneys. If they call me and say, we're going to pull this, we're going to pull that, we've been able to agree on all of the cases. What concerns me, though, is that there may be defense attorneys out there that are unilaterally pulling out the records before the records go to the QME or the AME. But I have not seen that happen yet.
Okay, so how are we handling it where both sides send records? What I do is I write a letter and I say, listen, here's my list of records. This is what we're sending. I'll handle the record.
Right.
Is that acceptable?
Yeah, I've been letting the defendant submit the records and
Yeah.
handle the attestation.
You know, one solution that I found I have a complex case with a guy who had a heart condition, suffered a stroke, was in the hospital for a long time. So the records are probably approaching 10,000 pages, and we're on to our third or fourth specialty. And now we're getting into, we've had a neurologist and a cardiologist, and now we're getting into ENT. So what we agreed to do is to send to that third or fourth QME the existing med legal reports that have already reviewed the entirety of the subpoenaed records and say, we're sending you these records, these reports that have reviewed it. If that's sufficient, great. If it's not, and you doctor need to see the subpoenaed records, let us know. So it may not be ideal, but I think it's a good cooperative approach in the right case.
Okay.
So that
we have two cases that we want to get into on this topic. The Brar versus County of Fresno. These are not in your materials, so I'm going to read the cite to you. It's 21 21 Cal Work Comp PD Lexus 36 86 CCC 430. This is a case dealing with the issue of whether or not either party can obtain a QME during the delay process. What tell us about this case?
Yeah, so this is a case where claim was filed and there had a denial notice had not yet issued, and the applicant requested a QME panel under Labor Code Section 4060 before the claim had been denied. Defendant objected, and ultimately the board determined that under the med legal procedures, and specifically a panel under 4060 where compensability is at issue, there is no need to wait for a delay or denial letter before a party requests a panel QME. And the rationale that the court applied is that the changes that were made under 863 to the process were designed to remove barriers to speed up resolution, and that there really is no benefit in waiting until the carrier formally issues a delay notice or a denial notice. In other words, the moment a claim is filed and it is not yet accepted, there, by definition, exists a dispute as to compensability under 4060, which allows either party to go out and request a panel at any time after the claim is filed and before the claim is accepted or denied.
Now, the argument from the defense perspective is that we should be able to complete discovery before that final report is released. I don't have a real strong argument why we should delay the medical legal process, and I think this is probably the proper interpretation of the law. What do you think, Jake? Am I missing something there?
No, I think you're absolutely right. I think that under the way the statute's written, I mean, the defendants have 90 days to decide whether to accept or reject liability. That's a long time for the applicant to cool their heels waiting for even requesting a QME panel, which could then be another 6 months down the road. So I tend to agree. I mean, I agree that the statutory process allows it. One sort of wrinkle in this is to make certain that there's a claim form filed, because what we see a lot of times with cumulative trauma claims, with first filing by the applicant attorney, there's no claim form, and when there's no claim form, 4660 is not triggered. Yeah, sure. So you're not allowed to go out and get a QME evaluation until there's actually a claim form filed with the defendant. Now you can have an agreed medical exam after that, but in terms of getting a QME, supposed to have a claim form. So I've used that as a fallback on some of the cases where I thought applicant attorneys were rushing to get a panel just so they could get a chiropractic panel in case where the applicant's had back surgery, that kind of thing. So I've used that. I don't pull it out all the time. Or somebody goes out and just files an application, starts requesting QME panels. I'll raise that as an issue.
Jake, I got to say I'm perplexed because in my practice, the vast majority of cases that I get come to me long after the claim's been filed, usually long after the 90 days has gone by. Or they're claims that I am filing on behalf of my client for the first time, often a cumulative trauma, because most of my clients don't know what a cumulative trauma is until they've met with me and I've told them. But when I file what I call my opening packet, or I tell my staff file all the usual stuff, that includes 1, an application, and 2, a claim form. Because the claim form is what starts the process. That gets served on the employer. That starts the 90 days. I'm literally shaking I don't understand how you could start a claim by only filing an application and not filing a claim form, but I realize I don't see all the things you see.
In Southern California, approximately 50 to 60% of all claims, the first presentation is the application by the applicant attorney.
Well, right,
so
but don't
it's a whole different ballgame.
And they don't file a claim form with that? Okay.
A lot of times they don't.
All right, well, that we're going to chalk that up to NorCal versus SoCal, so, okay.
And very, very, absolutely, very much so.
So I just wanted to chime in. I think this is a really good potential case. I don't know if the medical unit with the DWC will follow suit and allow us to request
Well, that's the
panels.
issue. Yeah, that's the issue.
But I do know that there's a lot of cases that are denied that I see in my public safety cases where they deny them pending the results of a QME.
Well, let me
Right,
ask you
go
this.
ahead.
How are you going to handle that then? You're submitting a request. Are you going to, I don't know, append a copy of this case along with...
Well, I don't know is the answer.
Yeah.
But it does create other logistical issues, though, and I think, Rich, you touched on this, is that if I go out and subpoena the records with my claim form and application, and I'm ready to go as soon as I get those records in, will the defendant have the information they need to submit to the QME? In other words, is that going to expedite the process by which the defendant sets my client's deposition? Is it going to just kind of fast forward all the
And I think
discovery?
from the defendant's perspective, our fallback position would be, if you get a QME, to object and then initiate discovery. We may be beyond the 90 days at that point, and there may be a presumption you have a medical as well. So there may be some other issues there.
Yeah.
Okay, let's talk about the next case.
Yeah, so this is, I'm going to say this wrong.
Let me.
Yeah, go ahead. No, go ahead.
Well, I'll say it wrong too.
Okay.
It's Kowal versus County of Los Angeles. The site is 21 Cal Work Comp PD Lexus 305. That's Cal Work Comp PD Lexus 305. It's a board panel decision, as was the prior.
So this is a case, kind of a post-Navarro question of does the filing of a new claim form subsequent to a prior injury allow the parties to get an additional panel QME? And the answer, the board said, is yes. There was a CT claim for a number of body parts, spine, upper extremities, skin cancer. Got a QME, was evaluated. Then after that evaluation, the injured worker filed a new claim form for a new cumulative trauma for largely the same body parts. Then that second claim was denied. A second QME panel was obtained in connection with that second subsequent claim. Defendant objected, said, hey, wait a minute, we already had a panel QME. You were already evaluated. You don't get a second bite at the apple. They went to the board, and ultimately the decision was that under Navarro, the trigger is the filing of the claim form. One of the things here that was interesting is that subsequent CT claim that was filed was for a prior date of injury. In other words, the date of injury that was alleged was before the first claim that had been filed, but the claim form itself wasn't filed until after that first claim. It's a very fact-specific thing, but basically if you get hurt and you get evaluated and then you file a new claim form, you can get a new QME. And I get the decision. I don't like it. I don't like the result.
Well, I don't like the result either. But tell me this, when I read this decision, I thought a critical fact was the fact that they said you're going to get a medical legal because it's premature to determine or resolve what was unresolved, date of injury. Do we have another date of injury? Is that an important part of the case? I thought it was.
It is, right? In other words, the board says, we don't have enough information. A claim has been alleged. You need to have it evaluated. And under Navarro, right, the doctor is supposed to evaluate all claims that have been filed at the time of the evaluation. Because in this case, when the first QME evaluated, the second subsequent claim had not yet been filed, so that doctor didn't have to evaluate it. And under the labor code procedures, when you file a claim and it's denied, you can get a panel.
Would the holding have been different if the doctor had addressed this earlier CT period?
I wonder that. Frankly, I'm always worried now if I have a specific claim, let's say, that gets filed and we go to the evaluator and that evaluator says, you know, there's also a CT claim here, and then I file that CT based on that doctor's opinion. I always worry that a defendant will then get a new second panel QME on that new CT claim that I filed.
Right, so I had this issue as a trial judge, and, you know, there's no question that Navarro talks about the claim form being the operative act. But I have to tell you, I really question whether the Navarro case is good for the process. I mean, there literally could be 3 or 4 QMEs on a particular, applicant, and I just don't know if that really helps anybody get a case resolved.
Well, it's what you said earlier.
Let me jump in here, because one of the issues that comes up in this is, what if the subsequent or even prior CT involves another defendant who's had no opportunity to develop the record? And I'm sure, Rich, you've been in that position. I've been in that position. This case has allowed me, or this kind of approach has allowed me, to go out and get my own medical legal to be able to challenge would maybe somebody trying to move a record on, for instance, the Guarantee Association trying to move the record onto my client when maybe it really shouldn't go there. Yeah. So this is a case that works not only just for applicants, but also for defendants. The defendant may be able to go out and get their own rebuttal QME evaluation. Yeah.
And it gives the defense side another bite at the apple. Because let's say the co-defendant had a bad one, I get a chance to change that. And also to discuss suitable AMEs to reconcile the entire record rather than muddy it up.
That's what you're going to end up with, is hopefully a settled case or an AME, because you start getting too many cooks in the kitchen with the QMEs. I mean, God bless them. We need QMEs, but you got 2 or 3 different doctors with 2 or 3 different opinions. I don't know.
The next case I want to touch.
Sometimes the doctors get completely different histories.
Right.
Now, I actually have a case, just had an appearance yesterday in the case. We have 2 psychiatric evaluators. My claim is the original injury, then there's a subsequent cumulative trauma. They got a new doctor. That doctor has a completely different history than the doctor in our evaluation. Our evaluation doctor apparently didn't pay any attention to anything. And the new guy has a much better, much more thorough history and is reviewing a bunch of records the first doctor didn't. So that one is actually going to be much more helpful to me than the QME exam in my own file.
The next case I want to touch on is the Estrella versus State of California. This can be found at 2021 CalWork Comp PD Lexus 316. Just a quick comment. I've always said that there are 4 ways to establish whole person impairment and or resulting disability. One of those is Guzman, and I've always said that Guzman has 3 elements that are required. The first element is the standard rating under the standard method chapter or table of the 5th edition. The second element of that is the doctor has to explain why it is that standard rating is not accurate. And third, the doctor has to address why the alternate rating within the 5th edition is more accurate, or I say complete. I substitute complete when I discuss this with accuracy. In other words, what is it about the standard rating that makes it less than complete, not accurate, inaccurate, and what is it about the new rating? Now, the Estrella case kind of provides us with some further analysis on that. What happened there?
Well, so this is a case where there was a number of injuries, right shoulder and spine, cumulative trauma claim, and the QME gave strict ratings for both the spine under DRE and the shoulder under range of motion, and then gave alternative or Alvarez-Guzman ratings, one analogizing to the hernia table due to loss of lifting capacity. In addition, they added an additional impairment under the DRE, saying that they didn't fully capture the loss of the spine, and they added an additional rating for the shoulder using strength, saying that the range of motion rating didn't accurately capture that. Ultimately, that doctor's Alvarez ratings, or Guzman ratings, were not followed by the board, and I think it really boils down to substantial medical evidence, right? The doctor did not do a good job of that 3-part test of 1, clearly explaining the strict ratings, 2, clearly explaining why the strict ratings were not accurate, and 3, giving a well-reasoned explanation as to why an alternative or analogous rating was appropriate. So one, I think we included this. This was in the CAW Winter 2022 materials. One, because we like to be fair and balanced, right? We don't always just put cases where we win. This was a case where the injured worker lost.
I was surprised.
But here's what I want to. One, if you're using the hernia table and it's not a hernia, be careful. There's a lot of cases on that. I think generally it's disfavored by the board. I think it's just too easy to analogize to the old schedule, loss of lifting capacity. The other thing, though, that really was interesting in this case is there was a dissent by, I believe it was Zalewski, Chairwoman Zalewski, who dissented, saying that she would have upheld at least some of the doctor's Guzman ratings, specifically on the shoulder, about combining range of motion and strength. I believe that's what it was. One of the things the majority said was that the doctor has to follow the instructions in the guides, where the guides, for example, like let's say, not in this case, but another case in the lower extremity chapter, they say you can't use gait derangement with any other rating method. I believe under Guzman, if the doctor wants to use gait and another rating, if they explain why, they can, and the dissent in this case, I think, would agree with that.
Yeah, it's the analysis that I think carries the day on this. But tell me this, I don't have a note on this. What happened? Was this remanded for further development of the record, or did they just rule that the burden of proof was on the applicant and therefore you didn't meet it, you lost? I don't know. I don't have a note on
So I believe what happened is that...
was it remanded?
They upheld the trial judge's decision.
No, it wasn't remanded. They, I think they... just gave the strict rating after recon. So
okay, we're going to skip, other than to mention the County of Sacramento Sheriff's Department versus WCAB. This case can be found at 86 CCC 845, and I'll just say it really quick, which is this: what happened in this case is there was a trial on whether or not there was stress that resulted in the workplace, retaliatory stress that resulted in injury. And there was a determination, a jury trial, a determination. What they said was they discussed the difference between res judicata and collateral estoppel. Res judicata is what? Claim preclusion. Collateral estoppel is issue preclusion. And they did the analysis under both, and they said in the end that it applies, and the WCAB was bound by the jury determination. Let's move on to the MPN decision on the next page, the Gonzalez versus AC Transit. This one can be found at 2021 CalWork Comp PD Lexus 71 86 CCC 624. This is a continuity of care case. Do you want to?
Yeah, so this was a case, it was filed, it was denied. Injured worker was treating outside of the network with their own doctor. Case was finally accepted. The employer sent an MPN notice, tried to pull the worker into the MPN, and the worker's treating doctor, to their credit, wrote a continuity of care report and said, actually, no, we're in the middle of care. The continuity of care exception applies, and there was also pending surgery that had been requested, which would be another trigger to stay with the doctor outside of the MPN.
Within what period?
Oh, is it
180 days?
180 days, that's
yes.
right, 180 days. And that was the schedule. Their surgery was scheduled to happen within the time frame. And the defendant fought it, and ultimately the board upheld the injured worker's right to treat outside of the network under the continuity of care exception. To me, this is a case that you really need to apply common sense. And I think what the board kind of said here is, defendant, why are you fighting this? Had you not fought this fight, the worker would have had their surgery, been back to work, less TD, less exposure.
And that's really the issue, because it was a certified surgery.
Yes.
They went through UR, and it was within the 180 days. What I took away from this was the definition of the triggering event. And I have written down here that the MPN coverage effective date is the date defendant accepts liability and first acquires the right to transfer applicant's treatment to the MPN. Where that surgery is within 180 days, and I think it's just the authorization, not the actual surgery, within 180 days of that effective date, when the defendant can first transfer it in, then the continuity of care is going to carry it. And on the defense side, as long as it's a good surgeon and there are objective findings, and we know that here that was the case because it was certified, why is the defendant And I just wonder, what's the end game on this? What are you doing?
So Rich, if I could, this is actually a case that I was going to cover a little bit later in the presentation.
Oh, no.
That's on
I'm
page
sorry.
9. That's okay. No, that's, you guys did a better job than I would have. But it's at page 9 of your materials.
Okay.
And it caused me to go back and reread the labor code section and the regulation.
Tell us about that.
Well, it is really clear that in this case where the UR certified the surgery, that the surgery was going to happen. And so this, in the box in your materials, it really kind of...
What did I write?
Well, it's actually really helpful. It says the decision is easily summarized by one question. What was the defendant's end game?
Yeah.
Was it merely delay?
And that's from a defense attorney.
Right, because it really, this delay, that's all that happened here. It was sort of delayed the inevitable. So I went back and reread the statutes, and it's quite interesting because it was clearly an appropriate, the treating doctor, like you're saying, Jason, did everything he needed to do. It then got certified through UR, and they were still fighting over whether the continuity of care applied, and it really raises the question of what was the point.
So I'm going to go out on a limb here. Last year, CAW had a bill in the legislature that would have created a statewide medical provider network. In other words, it would have taken every single existing network, and there's something like 24,000, I think, networks, MPNs, that have been certified by the DWC. I mean, it's an insane number. It literally would have taken every single doctor that's in every single certified MPN as of January 1st, put them on one statewide master list, and every worker in the state could choose from one list. Just like we have one QME database for the state, you have one medical provider network for the state.
What happened to that?
Well, it got killed, and the reason it got killed is because the insurance industry complained that doing so was going to eliminate their MPN contract discounts that they have. In other words, what we learned is that we have a fee schedule. We all know that, right? Doctors in the MPN, they get paid by the fee schedule. However, many, if not most of these MPNs require as a condition to be on the MPN that the treating doctor sign a contract agreeing to take less than the fee schedule payment. In other words, they don't get on the MPN unless they agree to take less than what the fee schedule provides. And the number that was quoted was somewhere between $200 and $220 million a year in potential network savings that were going to go away. Now, I'm not saying that's what's at issue here in the Gonzalez case, but it makes me wonder if that's one of the reasons that defendants fight so hard to say MPN, 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 and kind of miss the bigger picture. It all boils down to perhaps they want to pay the doctors less than what the fee schedule provides. Now, I know that sounds a little cynical. I'm just throwing it out there.
It sounds very cynical.
But you read this case, though, and you're really left wondering, like, what was the point?
I didn't like it.
Yeah.
I never would have taken that position.
Well, you hate to see this in the process.
I'm with you, Rich. I never would have tried this case.
Yeah.
I would have told the client, just start paying. It doesn't make any sense to litigate this issue that is so clearly one you're going to lose.
Well, what's nice is, as you mature in your practice, is you can tell the client the sad truth and take a position that they need to take. So, hey, I wanted to touch really quickly. The next case that you discussed at CAW, you guys discussed at CAW, was that Berkshire Hathaway Homestead Companies versus WCAB Perez. This had to do with the offer of medically appropriate modified work to an injured worker during a period when they were temporarily disabled, and then the position was terminated due to COVID shutdown.
Correct.
You don't think that the defendant should be liable for that period of TD, do you?
Absolutely, they should.
And explain that case to us. What's the theory?
So first off, the site for that case, 86 CCC 997. 86 CCC 997. The board there held, and there's been a number of other panel decisions since the pandemic started that have all held the same thing, that if someone is temporarily partially disabled with work restrictions, the employer has two options. Either they offer modified work or they don't. If they offer modified work, the worker is working and either entitled to wage loss or not, as the case may be. And if no modified work is offered, then temporary disability is owed. And what the board here said is that it doesn't matter why modified work is not offered or is not available. It doesn't matter if it's the employer's choice or not. If modified work is not available, even due to a global pandemic which prevents the business from operating, if modified work is not offered, then temporary disability is owed. And again, this is consistent with about 2 or 3 or maybe 4 other decisions that aren't in the materials. I had a trial on this a couple of months ago, so I researched the issue. In addition to Perez, I found a few others that were all consistent.
Yeah, in fact, we're going to talk about another one later on.
But if somebody can't go to or report to modified work because they have somebody at home who's immunocompromised and they can't bring the COVID home, so therefore can't go to modified work.
But the employer is offering modified work.
The employer has modified work available.
I think that's a stronger position for the defendant. I don't think that we would be obligated.
I have that case right now.
But-
Yes, I'm not feeling too confident
Yeah.
about
But did you see I cited in what I circulated among the presenters is the Escobar versus Wood Ranch. And if COVID extinguished the job, but the applicant was going to be terminated or turned down that modified prior to, then that would release the defendant from their liability for TD.
Correct.
So,
And I've always hated those line of cases, but I understand they are what they are. So,
okay, now we're going to go to the prepared materials. We're going to skip ahead in what the presenters have, and we're going to talk about the law of apportionment. I just want to give everybody a quick overview on the law of apportionment, just so we all start at the same point when we discuss these cases. And Dudley's going to, Mr. Phoenix, Judge Phoenix, is going to be addressing the Ross case, which is kind of an interesting case. When I read it, I said, wow, I hadn't really thought about that aspect of 4664, but it's something that bears some mentioning. But let me just give you an overview of the law of apportionment. This is the way that I have it organized in my head. You may want to adopt it. The first question that you have to ask yourself, are you dealing with strict legal apportionment or apportionment of liability as between co-defendants? They're different animals. While strict legal apportionment under 4663, apportionment to causation of disability, can reduce the award to the applicant, apportionment of liability does not. You're reallocating or apportioning as between co-defendants for successive injuries or periods of coverage. And they're handled differently. Let's just focus on apportionment of liability. Apportionment of liability, strict legal apportionment, you have to know, I say, 3 things. Number 1, burden of proof. Who has the burden of proof? Well, I've said this over and over again. It's a pretty simple doctrine. The party that benefits from the affirmative on the issue has the burden of proof. And who benefits from apportionment? It's always going to be the defendant. That's the old Pullman-Kellogg case. So it's the defendant that has to come forward and establish the apportionment, has the initial burden. The second thing are the 2 standards. We have 4663 and 4664. I'm going to go through 4664 briefly because I know Judge Phoenix is going to go through it in a moment. But what I say there is it really has 2 primary aspects. Number 1, a prior award, and that's going to be either an F&A or a stipulation. It's not a compromise and release, and that's the Pasquato case. Why? Because a compromise and release is a compromise of all issues, is a release of liability, and there is no award of PD. Okay? So it has to be an F&A or a stip. Second, you have the issue of overlap. And that means that generally it's going to be the same region or part of body. It's going to be the same matrix, and that's that Hahn case that came down that really gives us a lot of understanding on what the same matrix means. So that's apportionment to a prior award under 4664. 4663 is really a substantial evidence statute. And I always, when I read through a report on whether or not the apportionment is valid, I always have this checklist. First of all, is the report based on a full, complete, accurate medical history with a proper diagnosis? Second, is that opinion expressed in terms of reasonable medical probability based on the doctor's education, training, and experience? And then last, how and why? This is where all the litigation generally is. Has the doctor gone forward and explained to us why he finds apportionment to an event, activity, or exposure that's pre-existing and or non-industrial? The last issue that we see under apportionment is the Benson Doctrine. And the Benson Doctrine holds that where successive injuries are not inextricably intertwined, that you can apportion as between each injury the PD. And of course, from the defendant's perspective, we save a fortune on that. Now, I mentioned the Hahn case. I want to give everybody the site so they can review that. That's Hahn versus City of San Francisco. That's 2018 CalWork Comp PD Lexus 431. That's 218 CalWork Comp PD Lexus 431. Okay, Dudley, can you tell us about the Ross case?
Sure. So I think a lot of people, when they think of Labor Code Section 4664, they immediately think about the prior awards and apportionment to a prior award. And you were just touching on this, and the Coppin case happened to be my case back in 2006. And that was the issue there, is what was the defendant's burden when trying to basically reduce the current disability based on the prior award. And in the Coppin court, the third district set forth what the defendant had to prove, and a lot of it did go back to Pullman Kellogg, the defendant's burden, and so forth. So that was sort of the focal point on 4664, is what do you do with these prior awards? More recently, I have been spending time on another section of 4664, and that has to do with the culmination of awards, meaning that you cannot, an injured worker cannot have more than 100% awarded for any particular body part or area as described by the statute. The case I'm going to address is called Ross versus the California Highway Patrol. And in Ross, applicant had received a total of 59% in prior awards. And the prior awards were for the irritable bowel, skin, I believe they were, circulatory system, digestive, and so forth. Those awards totaled up to 59%. He then had a more recent injury that rated higher to the, I believe it was to the cardiovascular system. Here the board employed the catch-all provision, which you will find in 4664 C1G, where basically it's a very broad definition of a body part, including the head, face, cardiovascular system, respiratory system, and all other systems or region of the body not listed in subparagraph A through F inclusive. Well, if you carefully read that statute, that catch-all provision covers a lot, which means that it's very easy to build up the percentage that is applied to the prior awards.
Is there a difference here, and this was a question in my mind, between overlap and culmination as far as what the defendant may want to argue? Which is easier, or is there a difference? I don't know.
Well, so I have this issue going to trial on Wednesday of next week, actually.
Oh, boy.
Coppin, of course, says that in order to apportion to the prior award, the defendant has to prove overlap, right? Overlap between the impairments. So I took that approach in this case I have coming up, and I said, well, the prior awards don't directly overlap because they included body parts that aren't contemplated in my current case. Unfortunately, the defense attorney pointed out that they in fact do. So this is a really tough issue for the applicant, quite frankly. If the defendant can prove up the prior awards and the prior ratings, in my case, it's causing a reduction in the outcome from 64 to 61% because my client had a 39% award on the very same body parts. So and it is a very broad statute. So I think from the applicant side of the case, I think we're going to see defendants raise this more and more.
And that's the problem with the apportionment statutes. They're not only broad, they've been applied broadly.
Right.
So-
Well, let me just say,
Sure.
I had this case, like Ross, where we had a correctional officer who had a prior injury settled at 95%, included psych, internal, GI, and whatnot. And then after that case settled at 95% stipulations, he then subsequently suffered a heart attack after retirement, but within the presumptive period. So we filed a new claim for that. That claim on its own rated out to 76%. However, because the heart falls under that catch-all of 4664 C1G, right, everything else, there was the accumulation between all of his prior disability for the GI and internal conditions were the same as the heart. So even though there was no overlap under Coppin, I ended up taking what would have been a life pension award on the subsequent heart attack claim and settling the case at around 24% because we knew exactly what the ratings were for the internal stuff on the prior claim. Now I'm going to go after the subsequent injuries fund and probably get an over 100%.
There you go.
That's what I'm going to do in my case as well. But just one more thing, Rich. I mean, I know all four of us do a lot of public safety cases, and whether you're a firefighter or a CHP officer, they're very dangerous occupations. There's a high risk of injury, and those cases particularly come into play here because my clients particularly have, a lot of them have numerous prior injuries. And so, again, with a little research, I think the defendant would, there's potential here from the defense side.
Yeah, and see, that's my point in the box. I think that, honestly, the cap is easier than the overlap within 4664.
I agree.
So, okay. The next case is a causation of disability versus causation of injury type case. And Jason's going to take this, but before you do that, can I just explain the difference between these two doctrines? This is the way, in my mind, it's set. Causation of injury is that threshold determination of whether or not you have an injurious event, activity, or exposure that results in disability or medical treatment beyond first aid that gives rise to an industrial injury. Here, it's a minimal standard under South Coast framing. It's something greater than zero, that there's an injurious industrial event, activity, or exposure. So that's a threshold issue. That's at the beginning of the claim. Later, once the applicant becomes medically permanent stationary, is the issue of causation of disability. And that really is the apportionment issue that we've already discussed. So that's the way to separate those two. Often they're confused because you may have different standards on either. And they may be different outcomes, especially with psych injuries. But, okay, tell us about this case.
Yeah, so this is the Weist versus Department of Corrections. This is on page 2 of Mr. Montalbo's materials. Jake and I actually, I don't think Jake's still on the case, but Jake and I for a while had this almost exact same fact pattern. Gentleman, injured worker here was a plumber who had pre-existing diabetes and had been diagnosed with diabetes for at least 10 years prior to the injury. On the job, he twisted his ankle, and then subsequently, because of that, there was some alteration in his gait. He developed blisters in his feet, and as a consequence of those blisters, developed an infection, ultimately ended up with bilateral below-the-knee amputations, which is just awful and horrific. I haven't read the medical reports because those aren't in the case decision, but based on my understanding and frankly assumption that the amputations were caused at least in part by complications from his diabetes, because I've seen that happen. I'm not a doctor, but I understand that can happen. So the question was, and then the medical evidence showed that this person was totally disabled, or at least that's what the applicant was alleging. They went to trial. The board found that the injured worker was totally disabled without apportionment to the diabetes. There was an appeal. The decision was upheld. So,
what was the rationale? Because I didn't like the rationale on this.
Well, it was two things. One of the ways they got to 100 was by using the KITE decision, that is, using addition instead of the combined values chart. When you asked earlier, by the way, about what's hot right now, that's another big issue right now about using addition versus the combined values chart. I'm having lots and lots of litigation about that, keeping my defense attorney friends happy.
And you're just going to the doctor to find out whether or not what their opinion is on that.
Absolutely.
Yeah.
And I'm framing it to the doctor as, is there overlap? In other words, I think KITE is one avenue, that is synergy, and here clearly if you have your bilateral legs amputated, I think there's a strong argument that there is synergy between having the bilateral impairments.
And I've always said that KITE should apply more often than not where you have different regions of the body. If the rating string is within the same part of body, you probably don't have, the combined value was intended, I think, in that situation.
But I think another avenue on this issue is asking about overlap or the lack thereof. Now, not everyone agrees with me. I've had plenty of contentious doctor depots on this issue, but I think if the doctor says that there is no overlap, then arguably the best way to combine multiple impairments in different regions is to add them. Now, again, here there was addition, but the other issue is that I think it's under the Hikita theory that this person's disability was the result of medical treatment rendered to cure or relieve from the effects of the injury, and under Hikita, if that's the case, there is no apportionment. Now, we have to contrast that with the Justice case that is not in the materials, and I don't know if it's cited.
It is from last year.
Okay, so it's in the materials, where the court in Justice, in my opinion, severely limited the Hikita theory. In other words, there they said, you know, it's not simply enough that the medical treatment results in disability like a total knee replacement. You can still have apportionment to pre-existing pathology. What they said in Justice is their interpretation of Hikita is that if the medical treatment results in a new, separate, distinct condition that arises from that medical treatment, then And if that's what results in the impairment, then there is no apportionment.
Well, I read this just a little bit differently. Big surprise there. Huh? The only way that I'm always trying to explain these decisions because I didn't like it. I think we all agree that the need for the amputation was a combination of an industrial injury and the diabetes. I mean, amputations are common with diabetes. But the only way I could explain this is really application of the doctrine of direct causation, that they were only rating the orthopedic, and therefore the orthopedic rendered the applicant 100%, and therefore it was justified. That's the only way I could explain this.
Well,
and I also thought about this. Remember the old Steinkamp case?
Oh yeah.
I spoke in 2008 at CAW, and there was a riot on the stage when I suggested, let me tell you about Steinkamp. Steinkamp involved a case where there was a total knee replacement surgery, and the applicant attorneys argued that, hold it, great, you removed the pathology, there's no basis for apportionment. We've subsequently learned that that's not the case. So maybe another way to explain this case is analogous to Steinkamp. What happened was the doctor didn't go back and say, or the defense attorney posed a question, that the diabetes combined with that resulted in the surgery that resulted in, if they'd gone through that whole analysis, perhaps the apportionment would have been there.
Yeah.
What do you think?
Well,
Yeah, no, I agree with that, and I think you see sometimes in these board decisions where they'll will look at what the impairment is from the industrial injury, and for example, they'll say, well, it was the orthopedic impairment that led to their inability to benefit from vocational rehabilitation, so we're going to give them 100%. There's almost a fairness element that the board invokes. And that's where this direct causation analysis comes from. You just see it from time and again if you read a lot of panel decisions.
Yes, I absolutely agree with that point. The more serious the injury, the more likely the award, right? I mean, and
let me jump in here because, as Jason said, we've had a similar case. It's not my case, but I was involved in it for a bit. I look at this and see it may be as you say, be very much a factual issue involving the medical record in this case. One of the things that I try and emphasize to doctors when we go through this kind of analysis, because I think justice applies here. I think if you ask a doctor and say, is the likelihood of this applicant having an amputation without the diabetes, what's the likelihood? The likelihood it's almost zero. What's the likelihood of the applicant having the amputation with just the blisters on their foot? It's zero. The diabetes is clearly playing a significant role. It is in the absence of the diabetes, you wouldn't have the medical condition. So I think if you can get the doctor to acknowledge there's clearly a causation of the need for the surgery, I think it takes it to the point where the board, this is something I think the Court of Appeals ultimately is going to have to decide. They haven't yet, other than they did, I think, in justice. But I think these kind of cases need to go up where you get somebody looking at it from a legal standpoint and not creating this argument about direct causation, which is the old absent the industrial injury, what would the applicant's condition be? That's not the law anymore. They're misapplying the law, in my opinion. So I think this is an issue we have to get to the Court of Appeals where somebody will look at this from a legal standpoint and not decide what they want the result to be instead.
Okay.
Just my opinion.
No, I think that's accurate.
Yeah, it's hard to, you get some unpredictable results when you see cases like this. And again, like I talk about the vocational rehabilitation where they find somebody 100% based on the voc rehab expert testimony when there's medical apportionment. Again, it is like Jake is saying, it seems that they want to get to that result because it's such a catastrophic situation.
Yeah.
But anyways, yeah, the next case, Rich, I think is that Hernandez case.
yeah, you were going to address that.
I could do this one fairly quickly. This has to do with an attorney's fee that an attorney charged in connection with a 132A case. And the attorney was requesting a 33% attorney fee. The WCJ gave him a 20% attorney fee. And he reconned it, and the commissioners basically said, no, we're going to give you a 33% fee. I think a driving factor here was the applicant himself was very supportive of the higher fee. And I would say, just in my experience, that when it comes to attorney's fees, the board looks at 132As and serious and willfuls from a very different perspective than they do the ordinary case. They're very willing to, well, I think they look at it more like a civil case as opposed to a workers' comp case, so they're more than willing to award a higher fee. So I think that was the driving factor in this case.
Can I just say, in my practice, I have never fought a 5710 fee. I just don't. If there's a problem, I call. And I've never been involved in attorney's fees because I think, you know, especially in the old days where it was 10 to 12%, I don't know how you ran an office on that. And 15 to 20, here's the analogy. Why is it if somebody gets run over on the road, not working, that their attorney is worth a third to 45%, and yet if somebody gets run over and they are working, their attorney is only worth 15%. You see my point? It doesn't make a lot of sense, but I never get involved in that issue. Okay, now we're going to move on to AOE COE, and Jake and I are going to take successive cases on this. Before we get into it, I just want to make sure that the audience understands that the test in Borrello is still good law, that Dynamex only applies where the issue of independent contractor is raised. So that means that to be within the course and scope of employment, this is what I say, the injury has to be incident to a consensual employment relationship, and we're going to look at benefit conferred and controller right to control. Okay? And I don't care what the issue is, what defense you're using, whether or not you're within the going and coming. All of these, those rules are going to apply, and your analysis, if you apply them, will allow you to reach the correct opinion. Okay, let me start with the Santa Clara Valley Transportation case. I'm going to read on page 4 on this decision. It says, I write that the employer provided the employees with sleeping and showering facilities on the premise, as well as a host of other amenities. Use of the facilities was permitted to all employees, but not required. No notice or permission was necessary to use them. After several years of employment, the applicant, involved in this case, moved her residence, and so she started using them. She started staying there. In fact, the night that before her shift that was to begin at 4 a.m., she stayed there. What happened? She fell in the showers. She hurt herself. And the defendant said, no, you're not within the course and scope of employment. We're denying this AOE COE. The board, as well as the WCJ, held finding injury, determining that the applicant was within the course and scope of employment through application of the bunkhouse rule. The bunkhouse rule simply stated, and think about benefit conferred and controller right to control. Where an employer provides premises for the purpose of sleeping, the employer is essentially liable 24/7 during that period that they're there. There's no way to get out of it because they're presumed to be within the course and scope. And again, it's because of the benefit conferred and the controller right to control that's present. That's what they held. One other case in the box that I want to highlight for everyone is that Perez-Lopez case versus Zenith Insurance. This was a case that involved a death due to a motor vehicle accident, and whether or not it was barred by the going and coming. It was a regular commute to a single location, the employer's location, but the applicant made an argument that, hold it, it's not a compensated commute. You may not have the right to control. It is to a single workplace, and all those are elements that you're going to look at on an application of barring it by the going and coming rule. But the applicant said, hold it, this was a carpool among employees. Does that bring it within the scope? And what they said was no, because there was no evidence to support that the employer was compensating or encouraging or providing any enticement for that, so it was barred. Okay, the next case is the Henderson decision, and this is one involving the ISI test. We've seen this over and over. I included it this year. Jake, you're going to tell us about
my case, Rich. I'm supposed to talk about it.
Yeah, I stopped. Yeah. I was just introducing you, Jake. I'm sorry.
Yeah, it's okay. I know you get carried away. So this is an interesting case, very fact-heavy driven case. The applicant the peace officer went to work in the morning. His shift was from 6 to 4 a.m. or 6 a.m. to 4 p.m. Early in the shift in the morning, he went into the gym. There was a gym on site that was used by the employees, and he did a workout. During the workout, one of the dumbbells fell on his head, causing him an injury. And the issue became whether the applicant was in the course and scope of employment. Was he engaged in an on-duty activity, or was this an off-duty social or recreational activity? The employer presented evidence that said that, first of all, the applicant, approximately 10 years before, had signed a waiver acknowledging that if he used the gym, he was using it for an off-duty activity and not for an on-duty activity, and that all use of the gym was off-duty. That was 10 years before. They also testified that there was a policy for the city that the gym was to be used off-duty hours and not during on-duty hours. To counter that, the applicant presented testimony as well as some documentary evidence, including a text, that he had actually sent a text to his supervisor saying, I'm going to work in the morning, I'm going to hit the gym to prepare for an off-duty activity or something that they were doing, a competitive activity, and I'll be at work. And the supervisor said, that's fine, go ahead. The supervisor testified that he considered the applicant to be engaging in the workout activity during his on-duty hours. The applicant said, I was doing it during my on-duty hours, and I routinely did it during on-duty hours. They also presented evidence that the employer never posted a notice in the gym saying that use of the facility was an off-duty social or recreational activity, and the employer did not have any liability for any injuries, something that's required by regulation. I think it's 9881C4. It's a required posting notice. And the memorandum of understanding did not have any language indicating that the use of the gym was an off-duty activity. So both the trial judge and the board concluded that the applicant presented sufficient information, sufficient evidence to show that they had a reasonable expectancy that this was an on-duty, not an off-duty activity, that it was part of the functions of his job. Obviously, maintaining physical fitness for public safety officers is something that their job expects them to do, and that they expect to do it, and that the city, by never enforcing the obligation for the safety officers to perform activities in the gym on the off-duty, they just let them do whatever they wanted to. They said, basically, you waived your right to pursue this as an issue, and it was held to be compensable. So I think the applicant's testimony, the text from between the applicant and the supervisor, and then the direct supervisor's testimony that he thought the applicant was at work on duty when he was performing the activities, really nailed it down for the applicant from that standpoint. I think it became a pretty simple decision for the board.
Yeah. Okay, the next case is not that simple. You know why? It involves some pretty complex medical issues. By
the way, Rich, I just want to mention one thing.
Okay.
Your little box case, the Redindez case, where the applicant's sliding down a banister, and the board said that wasn't horseplay. That's a horsepucky case. I can't believe that they would say that that's not horseplay. That is not what a railing is intended to be. They even acknowledge you're performing work activity, you're doing something at work, going downstairs in a non-approved fashion, but you're doing something that risks injury. That's the kind of decision that gets people to look at workers' compensation and say those people are a bunch of wackos.
Yeah, and you know what the analysis was, the rationale in that case was that the applicant was actually doing something that the employer wanted, which was descending stairs, just albeit not in a recommended fashion. That's crazy.
Authorized working in an unauthorized manner.
Yeah.
Sounds like work to me, but I don't know.
Okay, let's move on.
Hopefully you wouldn't have when you were a judge.
Let's move on to this Johnson case. I gave it to Jason because This is kind of complicated.
Because you don't like me? No.
Yeah, it's complicated.
So this is on page 5 of the materials. This is a case dealing with exacerbation versus aggravation, and you're going to find that there's a divergent view of opinions on this panel. But
okay,
the basic,
but I'm right.
The basic facts are this. The applicant was a fast food worker. They claimed injury, skin injury, eczema due to chemical exposure. The history was that the worker had a history of childhood atopic dermatitis and prior episodes of eczema about 5 years before the injury. The QME ultimately found injury, although there was a question about apportionment to genetics and apportionment to pre-existing eczema, and was apparently equivocal on whether it was an exacerbation versus an aggravation, specifically whether or not there was a worsening or a permanent worsening of the applicant's eczema due to the chemical exposure. It went to trial. Ultimately, this was a case that was remanded to develop the record. I think what's helpful about this case is the discussion that the board engaged in on what is an exacerbation versus what constitutes an aggravation. Definitely look at the cases in the box that Rich put in the materials, the Tannenbaum case and the City of LA. Those are kind of the seminal cases, in my opinion, on defining that. I think where we on the panel run into differences is you can have, in my opinion, something that constitutes an injury but is not a permanent aggravation, in that an injury is an event that causes disability or causes a need for medical treatment. And if that need for medical treatment is beyond first aid, then in my opinion, that constitutes an injury, and the injured worker would potentially be entitled to medical treatment and or temporary disability benefits, even if there was no permanent disability, even if there was no permanent worsening of a pre-existing condition, even if there was no need for ongoing medical treatment on an industrial basis.
Okay,
Now,
when you put it that way, I agree.
See
the influence I have?
This is great.
My point was that if it's something, medical treatment just involving first aid, that you're not going to have an injury. And if it's an exacerbation, you're not going to have an award of PD, because my distinction between aggravation and exacerbation is permanency, the word permanency. Do you have a permanent increase in the applicant's condition? And that's going to result in an award of permanent disability. And an exacerbation, by definition, returns to pre-injury baseline, and in which case the defendant's liability is pretty much extinguished. So,
I agree. I think there's been so much energy devoted for years over the distinction between aggravation and exacerbation. I think what's relevant, I think Jason pointed this out, is if an incident causes the need for medical care, you have an industrial injury. I think that the focus should be on whether, not necessarily the question of injury, but the nature and extent of the injury. So I think injury is just one part of it. Whether all of the applicant's problems and ongoing problems relate to that incident, that's a totally separate question.
Now, these are almost always issues that come up amongst defendants rather than with the applicant. It's kind of unusual. In this case, it comes up because the applicant has a significant pre-existing condition, and the question of exacerbation versus aggravation makes a difference. But most of the time, these arguments involving exacerbation and aggravation really come out down to arguments amongst defendants about whether there's liability on somebody else to share the exposure. And a lot of it comes out of SIGA trying to create new cumulative traumas and shove liability onto other parties. So the distinction becomes significant in a lot of those cases. I think for most injured workers, if you do something at work that causes you to have a need for medical treatment and disability, or disability, I think it's going to be an injury, even if it doesn't cause any permanency.
Look, we go back to the labor code, right? 3208.1, an injury may be a, quote, specific occurring as a result of one incident or exposure which causes disability or need for medical treatment, right? So yes, I think, Jake, you're right. I think it really is about the long-term effects. Often my clients, if they have a pre-existing condition and something else happens, they're not worried about, gee, what's my permanent disability award? They're worried about, how do I get medical treatment now? How do I get paid for being off work now? I think most of the time we're going to win that fight, even if it's a, quote, exacerbation. It's going to be a different story on future medical and PD. So, but we agree, this is good. I like
it's not good. It can't be good.
No, but when I was a judge, I was telling Rich and Jason earlier that there was clearly an incident, and the applicant clearly went and saw the doctor after that incident. and then months later was going to have a total shoulder replacement. And so they tried whether, the shoulder was, an industrial injury, basically. And I said, sure, that an injury happened, but the real question here is whether the shoulder replacement goes back to what was a fairly minor incident. And so I developed the record on that, sent them back to the AMA.
Nature and extent.
Yeah, I think the nature and extent can be, but I think that's overlooked sometimes when everyone's so focused on what was an aggravation or an exacerbation. I think sometimes it can be sort of a red herring as well.
Well, good defense attorneys, we raise those.
Okay, the next case is also to Jake. This is interesting. We're going to revisit the Prevet doctrine. That's the Gonzalez case on page 6.
Yeah, what's interesting about this case is that we really had to go all the way up to the California Supreme Court in order to get it right. In this case, the defendant was a building owner. He hired a contractor, an licensed contractor, to wash the windows on his building. The independent contractor obviously has employees. One of the employees ended up falling through a skylight, and they sued the building owner for having a dangerous condition and not providing protection to employees from falling through the skylight. What the Supreme Court held is when you hire a contractor, a licensed contractor, to do the job that they're supposed to do, the duty is delegated to that contractor to make certain that they provide a safe environment for their employees to work, and the building owner's only responsible for hidden or concealed dangers that they don't disclose to the independent contractor. So in this case, the skylight's pretty open, not concealed. They said the independent contractor is the one who's obligated to make certain that the employees are protected from that particular hazard. And I started thinking about, okay, so how do there are circumstances where the building owner might have some liability. And it could be, for instance, if they put roofing over the skylight, but they didn't put any supporting structure. So if the employee steps on the roofing, they fall through the skylight. That's a concealed hazard. They would have to disclose that. If they told the building owner, we're going to put protective barriers up around the skylights so your employees don't fall through, and they don't do it, they've assumed the obligation to provide a safe place to work, and they haven't done it. None of those kind of things occurred in this particular case. The employees simply fell through because they probably just weren't paying attention. I suspect there's a lot of contributory negligence on the part of the employee, because if you're somebody washing windows and you're getting up on a roof, particularly to wash skylights, you should know that you can fall through them if you do something. So that's really on the employee and then on the independent contractor. There's no obligation on the part of the building owner to basically do anything other than make certain there aren't any hidden or undisclosed dangers that are on the property.
So it's really, the way I look at this, Jake, and tell me if you agree, it's really a delegation of duty or retention of duty or creation of duty, and where does it lie? And that's what Prevet holds. We're going to go ahead, if you delegate by hiring an independent contractor, we're going to allow that liability to flow with that delegation of duty. So
absolutely.
And did you see the Sandoval case underneath that with the electrical engineer? That's kind of the same thing.
Trying to see if I looked at that one.
It's real brief. What happened? It's kind of akin. That's why I put it in there. Same theory. It was the hiring of electrical contractor, and somebody was obviously killed. And they said there was no duty because they were hired for that, and that's what killed them. And that went to the employer. So.
And there would be no expectation that the property owner would have any expertise and skill in electrical.
Exactly.
That's really why you hire an electrician, is because you don't want to go stick your own screwdriver in that electric box and have the bad result occur.
The next case is Dudley's going to take, and it's kind of akin. It's a 132A case.
Yeah, so this is also, I think I can handle it pretty briefly, but basically here, the parties in a civil case tried to incorporate a 132A issue in their settlement, and then tried to bar the applicant from prosecuting the 132A before the Workers' Compensation Appeals Board. Here, the board said, well, no, although the 132A is not a benefit under Division 4 of the Labor Code, it is incidental to those benefits, and so any settlement of a 132A has to happen through the WCAB. So the applicant was found not to be barred from going forward on the 132A. And I think that a practice note here might be, and you guys are probably better able to address this than I am, but if you do include a 132A in your civil settlement, go before the appeals board and get a stipend order and dismiss the 132A, and then you do have the board's approval.
I think that's the importance of this
Yeah.
from the defense side, absolutely.
Yeah, there is a case, and I'm trying to find the name of it, but there's a case that I think is up on appeal right now on the overlap between a FEHA claim and a 132A, and whether there is collateral estoppel if I think the worker in that case, if I recall correctly, had a poor result in the FEHA claim, and the question is whether they can then go litigate their 132A claim arising from the same facts, or whether they're prevented from doing so. And I think that's up on appeal right now. I know I say it because Ka, I think, is working on an amicus brief in that. But interesting crossover between the two. And back to that case you mentioned earlier on the collateral estoppel.
Yeah, why wouldn't you? Because that's issue preclusion. If
Right.
the issue resolved is going to bar the claim, why wouldn't you be able to do it?
Right. And I think the difference is that in Dudley's case, there was a settlement, and obviously you can't settle a workers' comp claim other than the workers' comp board. Here, though, it's not a settlement. There was an adjudication, a finding on the merits of the claim. Yeah.
No, I think you still have to submit a 132A, absolutely. The next case is Jake's. This is the Neal versus San Francisco case. And I gave it to Jake because Jake does a lot of professional athlete litigation. So tell us about that.
And this is a case post the changes in the labor code in 3600.5, which created severe limitations on the ability of professional athletes to pursue claims in workers' compensation. Prior to those changes went into effect in, I think, 2013, professional sports employees would frequently file claims in California when they had relatively little exposure in California, but because they had some exposure, California would assume jurisdiction. You'd get people with claims for benefits. We had cases where injured workers would file claims in multiple jurisdictions, get awards at other states, then come to California and make a claim for a cumulative trauma claim and try and collect for all the different injuries under an umbrella case in California. And they were quite successful at doing it. So the labor code change created some restrictions on it. But one of the things they did not change was the ability to get jurisdiction in California where the employee signs a contract in the state of California, and California assumes jurisdiction based on a contractual basis, that where you actually have a contract of hire executed in the state of California, California has a public policy interest in the enforcement of the employee's right to workers' compensation benefits. In this case, the applicant was flown to California, came to San Francisco, signed a contract with the San Francisco 49ers, played with the 49ers for approximately 1 year, thereafter went and played for several other professional teams for the next 5 or 6 years, filed a claim against all of those teams in the state of California, but the subsequent teams were able to get dismissed on the grounds that the employee had never played in the state of California while employed by them and had no contacts with the state of California. And the question was, could he then proceed against the San Francisco 49ers for the cumulative trauma claim? And the holding by the board was, yes, he could pursue that claim because he had a contract in the state of California and they had jurisdiction over the subject matter of the contract and the employee's claim against the 49ers. They said there's still an issue whether the 49ers might be able to get some contribution from the co-defendants, but I don't see how that's going to happen when they really don't have any jurisdiction over those co-defendants. They did not have a contract signed in the state of California. Mm-hmm. Their contracts were signed out of state. They didn't play in the state of California when the employee was employed by them. One was, I believe, the Philadelphia Eagles who might come to California periodically, but did not while the employee was playing for them. So in this case, we need to remember the limitations on professional athletes filing claims in workers' compensation not going to apply in cases where they have actual jurisdiction over the subject matter because of the contract of hire in the state of California. It becomes important when you're handling these cases to make certain you know where the contract of hire was signed, make a request for it and get it. A lot of the cases I have are United Football League, Indoor Football League. And we have no idea what these contracts are. I mean, they're out in the hinterlands. A lot of these teams have gone belly up years ago. So we're trying to puzzle through some of these cases under those circumstances.
Let me ask you this, Jake. Every time I pick up and I read section 3600.5, I find myself spending 2 or 3 hours trying to figure out what the hell it says. It just seems like there's so many, somebody needs to write an algorithm and create a program so we know where we are in this section. Would you agree with that?
It's, I have to say that I've read it a dozen times at least, and it seems like I have a different interpretation each time.
I as well.
I'm starting to get some clarity, but it can be very, very difficult. And I've got one where the applicant played 3 seasons in California, but he played 5 seasons in Canada. And the real question I'm going to ask is, there's a couple of years between college and coming to California. Where did he play between those years? He may have played in other places that you can't find a public record of, like the Indoor Football League, which was primarily in Texas. Sometimes you can find information, sometimes you can't. There's sometimes you can find newspaper articles that cover whether the employee played. It can be a real challenge. But the fact that he played for 3 years in the United Football League in the state of California for California teams probably means that he's going to be able to make the claim in California, even though his last 7 years were outside the state of California.
Tell me this, Jake, how often do you see where subject matter where jurisdiction over the parties is established in California, but subject matter jurisdiction and conflicts of law where the WCAB is actually applying per contract out of state laws or agreements? Does that happen with some frequency?
We've seen some cases where they have accepted agreements which said that you will apply the law of X state. And there have been some cases where they said, yes, we will apply a valid choice of law jurisdiction where you can show that California really doesn't have a vested interest. In other words, somebody signs a contract in Ohio. Part of this has to do with the provision that's saying if there's a reciprocal arrangement with states. Some states have reciprocal provisions that said if your employee comes to our state and gets injured, we will make them go back to your state to get workers' compensation benefits. If you have a reciprocal agreement that says that you apply the other state's law and we'll send that case back to California, California law says we'll do the same for you. So Ohio has that. I think Washington has that, Arizona, Maryland, a number of states have those provisions that say we'll apply the law of another state. And if you can show California doesn't really have a dog in the fight, then they'll send it back to the other state. And we've seen that in some of the cases. That's kind of like, some of that was like going back 8 or 9 years before all these changes occurred. But it's one of the other ways that those cases can be bounced back to another state.
Okay, Jake, you have the next one too. This is a medical treatment case, the CEHA versus Taylor Farms Pacific on page 8. It deals with UR service and what the obligation is if there is a defective UR on the and who has the burden of medical necessity.
This is an issue that comes up fairly often I don't think we have as many invalid UR decisions these days as we did 5-10 years ago. I think for the most part they're starting to get it down, both in terms of the time frames and the service. But on those occasions where you have a determination, and by the way, one of the issues in these cases a lot of times is it prospective or retrospective, because a lot of times if doctors are dispensing medication, that becomes a retrospective review. You have 30 days. It's not the 5 business days. So those are kind of issues you have to look at that. But in this case, the question is, what do you have to prove? Who has the burden of proof when you determine that the UR decision is not timely and the applicant comes in and says, okay, now I want the medical treatment. The doctor prescribed it, they recommended it, I get the medical treatment. And the answer is not necessarily. Because when the board, first of all, assumes jurisdiction, they have to find the UR determination was not valid. They have to find a reason, usually timing or service. If the decision is not valid, then the burden is on the applicant to show that the medical treatment that they want is compliant with the medical treatment utilization schedule. And if the evidence is simply the doctor requested authorization for the treatment and didn't justify it in the report as to why it's compliant with the MTUS, the applicant doesn't meet the burden of proof to show that the medical treatment is reasonable and necessary. And I've had this argument with judges at the board when they say, no, the doctor recommended it, that's enough. And I'm going, no, look at DeBond. The language in DeBond is very clear. It's also in Sandhagen. Actually, the original language is in Sandhagen. It's in DeBond that says that the applicant has the burden of proving that the requested treatment is consistent and compliant with the medical treatment utilization schedule. And if they don't have that, the applicant doesn't meet the burden and they don't get the treatment. So it's always a question of how good is the medical report? How much does it say? I would say most of the time, the medical reports aren't going to show compliance with the MTUS. At least that's my experience.
Okay, continuing with care, we have the...
By the way, one of the crucial issues in this, one of the times that we do see defects in UR is when the utilization review company's service schedule is not updated. When the applicant attorney changes or when the applicant becomes represented by an attorney and they're sending the UR determinations out and not sending them to the right party, that's a defect. Yeah. And it's really critical from a claims standpoint and a UR standpoint that they make certain that any changes on the mandatory requirement for where you send those reports is in the record and they send them to the right place. Because otherwise you're just wasting paper.
Can I ask the two of you defense attorneys a question? I'm gonna take a moment to get some free advice from the two of you.
Uh-oh.
How much,
I don't do that.
How much control do your clients exercise over the UR companies, right? Whether it's GenX, whether it's EK Health, whether it's, pick a company. And here's what I want to know. Is it something where your adjusters or whomever's processing UR and the RFAs, they send it off and then have a dialogue with that company in the decision? Or is it literally like they take it off their desk and it goes into the black box and whatever comes back, and that's...
I think
most of the time they never see it before it goes to the UR company. So it goes directly to the UR company who makes the decision.
So let's go back to Sandhagen, right? Because, there's this notion that just this like rumor that won't die, that everything has to go to UR. I hear it again and again. And what Sandhagen said is that when an RFA comes in or a request for treatment, right, the carrier and the employer can choose to authorize or they can send it out for review. And if they choose to authorize, that is a valid exercise of utilization review, right? It doesn't have to go out. But do they send it
Absolutely
out because...
Right.
What's that, Jake?
Absolutely right. I mean, any decision to delay, deny, authorize medical treatment is of UR function, and the carrier can authorize treatment as a UR function.
But why have the adjusters been aced out of that process in so many, as you say, it goes straight from the doctor to UR. Why doesn't that go to the adjuster first? And I realize it's kind of a rhetorical question, but I want to try to understand that.
I'll tell you why it doesn't go to the adjusters first. You only get 5 days.
Yeah, there you go. What the hell are you going
to send it to the adjuster?
What are you going to? I feel sorry for the adjusters. Honestly, they have to. That's the problem with, and I understand why they wanted short periods of time for UR, but that's the problem. I'd say two things though. Depending on my client and depending on the seniority of the adjuster assigned, they have the ability to triage it. They have the ability to take it back and make that decision or determination. Now, there are some clients that I work for where the adjuster has their policy is their policy. Everything goes through UR.
Yeah, sorry.
No, I have a case where they get the UR. It happens automatically. And I think there's been like 8 treatments that have been denied through UR that the adjuster then overrode and authorized the treatment anyway. So they're getting the UR out of the way so they comply with the 5 days, then they authorize the treatment anyways. But that creates so much uncertainty for the applicant as to whether they're getting the treatment, not getting the treatment. But yeah, there's something broken with that process.
Well, is it broken, or we need some safeguards on the?
Sure.
Okay.
Maybe it's a longer period of time. Frankly, maybe it's paying the doctors to respond to the UR request, right?
How did they come up with 5 days? Why not 15? That still seems pretty timely. And you can have the emergency care provision that is shorter, but give us 15, 20 days. Okay, I'm going to run for the legislature. Okay.
By the way, the reality is the carriers literally exercise no control of the UR companies, in my opinion. They just don't. And I think part of the reason is they don't want to be perceived as having any control of the UR companies.
Okay.
That would be a public relations nightmare. So I think there's a sort of scrupulous effort to avoid having any control or having any oversight over UR companies. That's why so many of them are independent of the carriers.
But in far too many cases, UR is being implemented with every treatment request. And I don't think that's ever what the legislation contemplated. I thought they would, like you were saying, Jason, that the adjuster was going to have more discretion on the handling of the file. And what I'm seeing is just it's automatic at this point. Everything is going through UR. And like you're saying, Jake, the adjuster doesn't even see it. Doesn't even see the RFA. It's just being shipped off directly. Again, I don't think that's how it was intended to work.
This is one of the unintended consequences of the time frame. Mm-hmm. The time frame is so short that there really isn't time for the adjuster to look at it to make a decision whether to authorize. I mean, it means they have to look at it. They have to get it in. They have to look at it the same day it comes, which they may be too busy to do. Then they have to make a decision. Do I authorize this? And they have to go look at medical reports and make a decision. And if they say, I can't make this decision, send it off to UR, now you're a day or two into the process. So the time frame really dictates how this is handled. There's really no choice but to have it go directly to UR as often as possible.
I still really like the idea where if you're with an NP physician, there is no UR.
Amen to that.
I like that idea a lot.
Yeah, it's because you're only getting MPN doctors because it's discounted. So don't.
Okay, the next case is Gonzalez. And that's Dudley's. This is a continuity of care case.
And so we talked about this case with Jason's materials. This is the case where basically the surgery was or the claim, there was the delay in the acceptance of the claim. The surgery was recommended. The surgery was certified through utilization review. And then the litigation began. And this is the case where, if the surgery was certified, the defendant probably could have saved a lot of money here by just authorizing the surgery.
Yeah, and by not doing that, what additional costs were incurred? Probably additional periods of TD due to the delay.
Absolutely.
Yeah.
Absolutely.
And look, the reality is, right, the insurance industry has done studies, not us at Cobb, but the insurance industry has done studies that show that when treatment is delayed, you increase a worker's likelihood of having a permanent disability by more than 40%. In other words, if treatment is given quickly, there's a much lower chance of that worker actually having a permanent disability, which is better for the system, it's better for the work, it's better for everyone.
That seems high, but I know that treatment denied is going to probably produce a couple of things, one of which is higher PD.
Yeah.
So.
Yeah.
Okay, the Patterson decision has certainly continued to ripple in our industry. This is on page 10. This is Jason's case, the National Cement Company.
Right. So in this case, the worker suffered a, frankly, catastrophic injury and received an award for 100% permanent total disability, resulting from a 2014 accident. Then, in January of 2020, the PTP submitted a request for authorization for inpatient residential care. Again, catastrophic injury. Defendant authorized it. This is the key point in this case. Defendant authorized that first RFA, but the defendant then said that the PTP needed to submit monthly requests for authorization to ensure ongoing payment to the facility. The PTP complied. And for 7 or 8 months, RFAs were submitted and were approved. And then in September of 2020, remember the initial request was in January of 2020, the RFA for September of 2020 went to UR and was denied. Applicant filed for expedited hearing. They went to hearing. I think this is very interesting. They had the nurse testify, a nurse case manager, this is amazing, that the monthly RFAs were required in order for the doctor in the facility to receive payment for the continued care and not to establish that applicant continued to need the inpatient care.
Okay, I put that in there, but you realize it can be relevant on both issues.
Yep, absolutely.
Okay.
However, and ultimately the finding was pursuant to Patterson, the defendant had improperly ceased care, and you put this in your materials and you underlined it because I think it's absolutely critical that in this case, applicant does not have the burden of proving the ongoing reasonableness and necessity of the care. Rather, it is defendant's burden to show that the continued provision of the treatment is no longer reasonably required. It's almost like a presumption. There's a presumption, once it's been authorized, that treatment like inpatient care, same as home health care in Patterson, it continues to be required until there is a documented change of circumstance that, Rich, your client has the burden. You like to talk about burdens, right? Would you agree this is a shifting of the burden?
I think you're putting me on the hot seat here.
Yeah.
No, I think your analysis is correct.
Yeah.
And that's why this case is here, so that my clients can understand really fully the application. And it's become pretty significant. I see Patterson applying to catastrophic cases where the carrier wants to make a significant change without a change in circumstances in the authorized care. Somebody comes in, takes a look at a case and says, hold it, we need to cut this, we need to cut our exposure, our expenditures. Why can't we cut this down? Let's submit it to UR.
Right. Now, I've seen cases in similar situations, mostly with medications, which I realize is different, and I'm going to rant about that in a moment, but where someone's been on long-term medications and the carrier or even UR will write to the PTP and say, we think that weaning might be in order. Can you develop a plan for weaning? Will you work with us to develop a plan for weaning the worker? And then they try it, and it either is or is not successful. I'm actually okay with that. I'm okay with another doctor getting involved, working with the PTP, trying something out, seeing what happens.
What do you do where the QME or AME addresses that issue? Is that a precursor to actually going to a trader and getting him involved to do it and say, here's an opinion, we'd like to try this. And here's another one. What about a less expensive medication? Because I have this case right now. We want, instead of injections, we want oral. And it's essentially the same thing. And the doctor who's treating says, well, it has to be injections because that's a better and we know we're getting a good result. Our position is, well, hold it, we should be able to go to tablet on this. It's costing us an arm and a leg. What's the reason for that?
Isn't that the treating doctor's call? I mean, the treating doctor knows the patient. They have a relationship.
Well, I don't think it's going to be with the medical legal evaluator. It's not going to be binding on the medicine, on the treatment, but it certainly ought to be discussed by the parties. I don't know, and use that as at a deposition to ask the treater, what about this?
Yeah, I mean, I'm not against things like that. The danger is then I see that being used as a way to control costs. This comes up most often in MSAs, right, where someone's on medications like, well, we need to go to the treating doctor and say, well, do they really need that medication, or can they get off this medication, or can they change this medication? Not because your client, frankly, cares about the health of my client. They care about, we want to save money on the MSA. So again,
okay, listen,
cynical.
When you say that angrily.
Yeah.
It's certainly on my side. It's about costs.
Okay.
Absolutely. I'm not going
to. But that's not my consideration.
Yeah, I understand that.
Right.
That's fair.
So I have seen cases, and this was a case I saw as a judge, where you had a utilization review doctor who actually would write thoughtful and fairly, reasonable determinations having to do with, my client was on like the applicant was on like 8 different medications. And so the UR doctor was trying to interact with the treating physician and was saying, hey, some of these are duplicative, basically, was the UR physician's stance on some of this. Well, he couldn't get the treating physician to engage. And ultimately, the applicant changed treating physician and did reduce, I think was on 3 or 4 medications at the end of the day. So I'm not really opposed to the UR physician interacting with the treating physician, but if it's just strictly
Well, I
to
think
save
that's-
costs because you don't want to pay for an injection, I
Well,
know that seems a little less sympathetic.
Before we
to me.
leave this, let me throw something else
Sure,
out.
sure.
What about cooperation on the MSA? Because there are motivations on both sides often to reduce the cost of the MSA. Because if we do an MSA, let's say that, and this happens with some frequency, I'll say to counsel for applicant, listen, we have an MSA of $250,000, but some of this, your client, you've told me, is never going to use, never going to. Why don't we do this? Why don't we split the savings? Go in, get a new MSA, generate the information that we need. That's going to do 2 things. It's going to reduce partially my client's liability, but it's also going to reduce your client having to self-administer a portion of that money that otherwise would be his, free and clear.
Yeah.
Do you guys engage in any of that, or?
I have done that on cases. Since you brought up MSAs, and again, I'm going to go back to what's hot at CAW.
Okay.
So-
Address the new reg.
Yeah, so many of you may know this. If not,
What is the new? What's the number?
well, it's not a new reg. It's a new. You know how CMS does? They issue memorandums, right? They have their
Guideline. It's a guideline.
They guidelines, right? You go into there, you Google WCMSA, Workers' Compensation Medicare Set Aside. The first Google hit is the CMS webpage, and at the bottom of that page, there's a link to their current guidelines, and it's a 80, 90, 100-page PDF document. They updated that in early January of this year. And the relevant section that I'm going to focus on that they updated talks about CMS's position on non-submit MSAs, which I'm sure you've seen it. It's been a big thing over the last number of years where more and more carriers are saying, let's not submit. And these are cases where submission would otherwise be recommended by CMS. That is, somebody is a Medicare recipient, and the settlement is for $25,000 or more, or someone has a reasonable expectation of becoming Medicare eligible in the next 30 months, and the settlement is for $250,000 or more, and the carrier says one of those criteria is met, but we are not going to submit. What CMS is now saying in their guidelines, their recommendations, is that if the parties meet the review thresholds, do not choose to submit the MSA to CMS, that CMS will then treat not the MSA, but the entire value of the settlement as the Medicare set-aside and require the injured worker to spend the entirety of the CNR
Wow.
as...
Okay, now, see, I just came across this 2 weeks ago.
Yeah.
And it was represented to me that it was a reg.
It's not a reg.
I understand it's a policy with CMS now. Boy, that's really going to make our jobs more difficult.
I had a mediation last
Actually,
week. Right. I had a mediation last week where that was a concern because the parties had a non-submit MSA, a very substantial one. And I was told that after that was issued, that somebody at Medicare did a public forum where they said that if the MSA is evidence-based and it's not submitted, then they will treat the MSA no different than if it were submitted. So I guess Medicare is trying to clarify that because that sent a lot of shockwaves.
Well, how does that change what we have right now? I have a client that will not submit. And then what happens there is the app attorney says, well, hold it, you don't want to submit, fine, hold my client harmless. I mean, up to the MSA. And so I tell my client we have to hold them harmless. That's if we want the CNR. And my client says, no, we're not going to do that. And so what's the solution there? I'm not sure there is one.
Well, there's a firm out of Florida.
No, I was going to say, one of the things, the guideline is actually, it's a little tougher than what Jason indicated. What the guideline says is, if you have a circumstance where an MSA would ordinarily be submissible, you meet the criteria, and you choose not to submit it and you do an MSA, they will interpret that as an effort to evade your obligation to protect Medicare's interests. So what they're basically saying is if you do that, we're going to assume you're doing that only for the purpose of avoiding your obligation, and we're going to take the entire amount of the CNR as the amount that's available. The applicant is required to spend the entire amount before Medicare will jump in again. So
there's no impact on the defendant.
Not really. It's really an impact on the applicant.
Yeah.
If the applicant never spends the amount of money, then it doesn't matter. If they stop getting medical care, don't submit it to Medicare,
That's true. I don't know
it
if
never
Medicare
happens. But if they do,
blows
it's a
up-
problem.
I don't know if that's true. If Medicare blows up a set-aside, sure, the applicant has liability, but I'm sure the defendant doesn't have any further liability
Why
either.
is that then?
Well,
We've got a CNR to protect us, and I've said this all along with MSAs. The MSAs are really for the benefit of the applicant and the applicant attorney. Two ways. Number one, the applicant may not be eligible for further Medicare, and number two, the applicant attorney may have an issue involving malpractice.
I'm not sure that Medicare couldn't go after a defendant for...
But they never have, and there's no case law on that.
That's fair.
And what would be the theory to do that? Because the obligation is really, the contract or privity of contract is going to be between the applicant and Medicare. We're just out here settling a case.
Here's why they're going to go after you.
Okay, because we have the money.
No, because if your client won't agree to submit the MSA to CMS, then your client's going to agree to guarantee it. And if they don't agree to guarantee it, and they don't agree to submit it, then we don't have a CNR.
Okay, but we have to guarantee it in the settlement, and my client won't guarantee
But there's defendants that won't guarantee it.
Yeah.
And so there's all these, whatever you want to call them, but you can get an indemnification letter from this firm out of Florida where they'll agree to indemnify the applicant's attorney in the event that Medicare ever comes against the attorney or his client.
Wow.
But again, there's applicants that aren't really comfortable with that indemnification. I mean, so there's all these ways that are being developed to get around these non-submit issues. So I don't know. I think the safer practice is to submit it to Medicare.
This is what I've told but the problem is Medicare, we on the defense side, we keep getting bit in the rectum by Medicare. I mean, we submit it, and it's always, if it's I just had one, if it's an $8,000, and they kicked it up to 14, which is, that's not but still, everything goes up when we submit it to CMS, and I think we're all seeing that.
Yeah.
Well, you brought up the issue of taking certain things out of the MSA. Like I had a shoulder replacement taken out of the MSA, so it of course significantly reduced the MSA. I get very uncomfortable with that when we're starting to determine what will or will not be included in the MSA, at least in the vendor's assessment. I've seen that happen with more regularity.
Well, if you have medical evidence to take that out, we don't just arbitrarily take it out. I don't.
Well, but in this particular case, because UR had denied the surgery, but it's still a Medicare-covered procedure, right? And so I think we're getting really kind of too creative at that point. But I don't know. That's just my personal.
So can I come back? I want to come back to the medical treatment, if I may, because I want to rant for a moment. So I think that the rationale that the board laid out in the Revoto case, which again we were talking about on page 10 of your materials, that is that for certain types of treatment, once it's been authorized, there's no need for continued RFAs, for a continued showing that the treatment is reasonable and necessary. I mean, why, for example, in this case, was it authorized for 8 months and denied on month 9? That literally makes no sense, right? If the person's catastrophically injured, totally disabled, in inpatient care, unless there's evidence that they're miraculously healed, they're going to need that presumably for the rest of their life.
Well, hold it. I'm getting hoarse yelling. Do you know that?
But here's my question. What else might this apply to? And more specifically, why doesn't this apply to medications? And I understand there are other cases after Patterson that say Patterson doesn't apply to medications. But with something like this, where they specifically say it's defendant's burden to show a change in circumstance. When a doctor has established a modality of care and is stable and says this worker has a certain level of function and a certain level of reduction of pain with these medications, and they get approved for 6 months, and on month 7 with no change in circumstances, UR denies it because there's no evidence of functional improvement, which is what the MTS wants, and there's only so much functional improvement you can have. Why doesn't something like this rationale apply to things like medication? And I don't have a good answer why it doesn't, but I'd love for you or Jake to tell me why I'm wrong to rant about this.
I'm gonna shift that to Jake.
I have to say, I actually just wrote an email to a client. They've been authorizing 2 medications for the applicant, 100% award. They've been authorizing them for the last at least year and a half. They changed UR companies. The next UR company non-certs both of them. I wrote the client and said, this is really, we're hoping at some point to be able to settle this case. This is the kind of thing that really interferes with settlement.
Yes.
You need to authorize the medication. And the client did. They authorized the medications. So they've been authorized. Otherwise, the applicant has no medication that she's getting. One of the things I also told them is, if the applicant's not getting these medications, now you're making the treating doctor go to some lengths to say, okay, what else can I do? Spinal cord stimulation, morphine pump, yada, 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 yada. Provide the gabapentin. It's cheap. Gabapentin is almost free. It's so inexpensive. So it makes sense to just authorize that on a long-term basis. And I, a lot of times I go to clients and say, this is not going to help the applicant. It's not going to help your claim. You're going to end up having more costs. You get IMR that costs more than a year's worth of medication.
But I think what you're pointing out, Jake, is that the Patterson rationale does apply to really all modalities of treatment. In your case, they had a good defense attorney, a good adjuster who basically applied the rationale of Patterson to an ongoing case. So I don't know to answer.
I think we have to be careful
Okay.
as to whether or not it applies to all modality of treatment. There is a line of decisions out there that suggest that it doesn't apply to medications. But I'm also going to tell you that, like Jake, I feel uncomfortable. Let me just throw something out there. I think that the worst cases that I've taken over from other defense attorneys is where you have an admitted injury that's catastrophic and they want to fight. And I'll just tell you a story. I had a case that was pulled from my office. It doesn't happen very often. And this case went to another defense firm. And I told them we need to finesse this. Why? Double amputee. Back, compensable consequence. Left shoulder and arm. The guy was probably 100%. He had a great attorney down in the Bay Area, and who I knew for a long time and I could work with. I told him I thought it was going to be 100%, but this is what we needed to do. They liked the guy, by the way, and the guy was a great man, the applicant. Every time I saw him, I legitimately hugged him because he was such a great guy. And he wanted to go back to work. And I said, so here's what we do. We get him back to work. We help him, and we pray that he never files a psych claim, because this is a 100% case if he does. They had a file review, and the claims examiner had not been reviewing his file on what I was saying, and he was asked a question. He nutted up and threw me under the bus. Nobody reviewed the file. I got a notice that it was being pulled. The claims manager called up and apologized for his adjuster, and I won't give any names here because they're still in the industry. And you can tell it still sits in my craw here. Mm-hmm. But let me tell you what happened. The case went from $3 million in reserves 3 months later to $6 million, then to $9 million. It settled for $14 million. Yeah. So the point is, on these large cases, like Jake said, you've got to be careful when you go to guns. You know, what you want to do on large loss cases is you want to, number one, you want an attorney that everybody respects. If you're a candy butt, it's not going to work. If you're in over your head, there's a problem. But I think you want to be aggressive but fair. And you want to quantify it and resolve the liability in your client's best interest. And attorneys that go in and think they're going to go to guns on those cases, it goes from $3 million to $14 million is what happens.
Yep.
So there's the war story.
Yep.
Okay, where are we? Are we done with this this case?
Yeah. Are we at break time yet or not? I don't know what we're doing.
Let's see if we can. You know what?
Do you want to keep pushing through?
No, let's take a break. I think everybody can take a break. We were supposed to take a break at 11 o'clock. We're going to take a break. I have 10 till, so we'll come back about 10 after or so. Okay?
Sounds good. Great.
Okay.